Juris Vodcast with Scott Pearce.
Sarbanes-Oxley is the most important business regulation to pass during the Bush administration. This law focuses on accounting practices. The Enron and WorldCom cases proved that independent audits were needed to prevent companies from lying to investors and to the government. Before Sarbanes-Oxley, the accountants regulated themselves, with disastrous results. The new law created a public company oversight board under the Securities and Exchange Commission to regulate accountants. The Free Enterprise Fund is a right-wing think tank that believes corporations should be free to defraud the public without interference from the government. It challenged Sarbanes-Oxley in court. The plaintiff argued that the Public Company Oversight Board is unconstitutional because it violates the separation of powers. It lost a summary judgment motion in district court. The appellate court agrees that the plaintiff hasn't brought a claim that deserves a trial. I am hostile to the Free Enterprise Fund. The lawyer who argued their case on appeal is one of the people who helped put President Bush in office by preventing ballots in Florida from being counted. Despite this, the technical arguments they offer in this case are interesting. The dissent in the appellate court decision deserves to be studied. It argues that the president, not the Securities Exchange Commission, ought to decide who sits on the Public Company Oversight Board. The dissent says this case is the most important separation of powers case to come before the courts in the last 20 years. The purpose of government is to protect the weak from the strong. Government must be dominant over big business in order to maintain freedom and public order. Sarbanes-Oxley works, but this case may be far from over.
Juris Vodcast is a production of Nuclear Podcast. Creative Commons Attribution, Non-Commercial, No Derivatives.